Open source patent protection, is that an oxymoron? No. Even if your intent is to open source your code, understanding open source patent law is crucial for company developing AI technology today. AI is advancing rapidly, fueled by open source contributions from company, universities, and independent developers. While this open innovation accelerates technological progress, it also raises an important legal question. Can or should AI technology that is open sourced be patented? The answer is yes, but under specific conditions. Open source complicates the patent process, but it does not prevent patenting. You may want to patent open source data to give you an extra degree of control over how the code is utilized downstream. So, company looking to protect their AI innovation should still consider patenting codes that they elected to open source. So, first, let's talk about the history of open source software. So, open source software is a type of software that's released under a license that allows users to view, modify, and distribute the source code. Some licensing agreement requires the user to then recontribute their modification of the open source so that others can use it. This concept has roots since the 60s and 70s, when software was often shared and modified by programmers in research settings. However, it wasn't until the 1980s that open source began to become popular as a term, and the movement started taking traction with open source code such as the code for Linux, for example. Today, open source programs play a major role in operating system as well as foundational network code. So, for example, the code underlying the IP networking code. A major type of license now is called the GNU General Public License, and this was developed by the Free Software Foundation by Richard Stallman in 1985. The GPL sets a precedent for subsequent open source licenses. In the 80s saw open source movement gaining a widespread popularity. In around 2000, the term open source was officially developed, and the Open Source Initiative, or OSI, was established to promote and define open source software. So, next we addressed whether open source software can be patented. It can be patented if you patent them before you release the open source code, or in the US, with the 1-year grace period, you can patent them as long as you're within the 1-year window. Patenting open source software can be used as a defensive measure to prevent others from patenting similar inventions. So that is a major objective of patenting open source software. This approach sometimes can conflict with the principles of open source software development. And so one alternative use of patent is defensive patenting, wherein the software is patented to prevent others from patenting similar inventions, and also to prevent your own company from being sued as a defendant by somebody else who patented their code ahead of you. So ultimately, open source software developers should navigate the complexity of patenting in addition to the complexity of selecting the open source licenses. So what AI innovations can still be patented? Even if the AI model itself is open source, there are a number of AI innovations that remain patentable. For example, you may want to look at the specific applications beyond the core code that was open source. So for example, if you have a particular code for AI, let's say if you develop AI, the large language model underlying code that you want to share with other people to improve, what you can use is you can patent the specific application of AI in the context of this. As an example, if you develop the underlying LLM layer, but you want to apply the LLM to a multimodal type of use, such as in voice processing, you could patent in the description. You can describe the LLM that you came up with and also the voice application on top of that LLM. And that way, the disclosure covers both. But in your claim, you may want to focus on your voice-specific application. So that's an example. Right. Other techniques that you can patent, including training methodology, the type of data, and how you fed it into the data. And because the training ultimately affects the end result. If you go to the Llama, you can look at all the source code, but note the cost of training the LLM can run into the hundreds of millions of dollars. So there's still significant proprietary interest in the process of training, even if you open source the underlying LLM model. You can also patent hybrid integration, such as combining the open source AI with a proprietary hardware or software. So let's say we came up with a particular, in the case of Nvidia, they have their proprietary hardware, the GPUs to run and train and deploy the AI. However, the code that they have, they can open source because they are encouraging people to go in and play with that. As long as that code is tied to the hardware, Nvidia would benefit. And in fact, the software layer is in fact Nvidia's secret sauce. Other competitors, such as, let's say, Intel or AMD, could not displace Nvidia hardware because Nvidia has provided these code available for AI training purposes, and there's such an ecosystem available that many software developers just simply stick with Nvidia for ease of software development, and that turned out to be a major competitive advantage for Nvidia. You can also patent the efficiency improvement. So a modification that enhance performance, reduce computation costs, or improve your accuracy, those modifications are definitely patentable. And so by patenting these innovations, distributors of the free open source code may still need to individually obtain patent licenses. And so that way the code is openly available, but for commercial use, you still have that ability to monetize the commercial uses of your open source code. So when you open source your code, obviously now you release all the code into the prior art, and the prior art can itself be used as a mechanism to prevent others from leveraging off your work and patenting them. So there's a significant prior art aspect when you open source your code, because other people can benefit from that, and also the novelty improvements from such code could be reviewed based on your open source code. So what is the interplay between copyright versus patent protection for AI and open source software? They are mutually exclusive, but there are different layers that you can consider in protecting the open source software. So a copyright protects the literal expression of the code, but does not cover the underlying functionality, the concept, or the methods. The patents protect the novel processes, algorithms, or system that the AI invention performs, regardless of how they are implemented. In the case of open source AI, you can have a copyright on the line of code, and you can also have the patents. And so you need to have both. The copyright protection can be done very inexpensively. The patent process is more expensive and takes longer time, but it can cover the whole concept versus the literal expression of the code. So the patents, harder to get, more expensive, but has broader protection implication. Let's talk about trade secrets versus patents in AI and proprietary software development. So similar to copyrights, trade secret is yet another layer in protecting software. So the trade secrets could arise from how you train the data. You can open source the code, but when you may have techniques to reduce the cost of training, make it quicker, you might even invent techniques to brush up the training, your prior trained data. And so all of that could be protected under a trade secret. Now, the downside of a trade secret is that you have to keep it as a trade secret. If somebody downstream reverse engineers how you do your trade secret, then the trade secret is gone. And if they publish that, then definitely the trade secret is gone. So that's the downside of a trade secret. That said, there are many trade secrets that are quite powerful and been kept over a long time. An example is the Coke trade secret, or the formula of Kentucky Fried Chicken batter. And so, yes, you can keep trade secrets for a long time, but it takes effort. If somebody independently reverses your trade secret, then you've lost that right. When you have IP protection on an open source, you need to think about the business models of how you benefit from open source. First, an open source provider can provide support and services. And an example of this would be the IBM Red Hat model, where they provide service and support for Linux open source software inside a corporation, and such support can include consulting, training, and maintenance. This model allows businesses to monetize their expertise and provide value-added services to users. You can also have dual licensing. So in this case, the model offers the software for use under an open source license and still provide a proprietary version with additional features for support. This allows the companies to cater to both open source enthusiasts and commercial clients and leverage off your expertise as the originator of the open source license. You can also have an open core model where the core of the model is open source, and then you have additional features, plugins, and modules as proprietary add-on models. This model balances the benefits of open source development with a future revenue from premium features. And you can also have software as a service model. Companies can simply provide the open source software as a service, allowing users to access and use a feature without the need for installing and maintaining the code. And this model offers convenience and scalability. So there are a number of benefits of this. This is where the open source models would tie into the IP and analysis of whether you should patent, you should copyright, or you should keep it as a trade secret. There's also a trademark aspect to this. You notice that Linux is trademarked, right? And so by trademarking it, the open source company can maintain further control on the branding of the open source code. So what happens if you don't get a patent for an AI innovation? Well, of course, you're going to lose your exclusive right. In the case of open source, you lose the right to control how the open source is utilized. You can have difficulty in securing investments for normal startups. So what happens if you don't get a patent? Let's jump out of the open source analysis and now let's broaden the issue of a software company and patent. So failing to secure a patent for AI innovation can have significant consequences, including loss of exclusive rights, difficulty in securing investments, inability to monetize the innovation because of copier using your code, and risk of being blocked by competitors who do patent their innovation. Without patent protection, companies have limited legal recourse. All you have to do is look at the case of Photo, Photo, versus Meta, where they did not patent their innovation, and then they collaborated with Meta, and then after a while they saw that the features of their code start showing up in the Meta software, and then without a patent, they really couldn't do much about it. So failing to patent could allow your partners, your competitors, and anybody else to copy you and then to removing the benefit from your work without restriction. So you should take steps toward protecting your startup's intellectual property. Visit us at patentpc.com and talk to us. We're here to explain all the tricks and tips on how you should apply the IP system to your software.